This material is made available to you by or on behalf of the University of Melbourne under Section 113P of the Copyright Act 1968. It may be subject to copyright. For more information, visit the University Copyright website.
Bugger. I knew it was going to happen at one stage. We've had a pretty good run. I'll see if I can put last year's recording on as well. Thanks for letting me know. So where did I get to? So before and after is a good way of assessing compensation. The site without the easement in place, and then valuing it with that easement in place, running it down the side. How does that impact if you can't build that particular type dwelling on there because you need access to build on a particular line, and this easement is going to throw all that out. Okay, so that's a valuation approach, but what do we need? What are we lacking in the before and after? So we need sales of land in the before scenario and land in the after, and that's sometimes difficult to gather. So sales is the way to determine the financial difference between land impacted by an easement as compared to not, but not always possible. So sometimes the valuer needs to put themselves in, again, the Spencer principle. What would a purchaser and a vendor agree to as a value of property in the before scenario and also in the after scenario? Again, not easy to do when there's a lack of sale, but generally there should be enough sales for you to analyse the impact of those sorts of things. For practical purposes, it becomes a matter of assessing the extent to which the claimant has been disadvantaged as a natural and reasonable consequence of the taking of the easement. Again, the words are pretty good to help us provide the framework of what we need to do, but in reality, sometimes that's difficult. But yes, look at the extent of the disadvantage of the creation of that easement on the property. What does that stop the owner from doing now that that easement is created? So you get an idea of the restrictions that exist. But the question is, financially, what does that mean? The test is the attitude of the hypothetical prudent purchaser and the extent to which, in the opinion of such person, the claimant has suffered reduction in the value of his or her property, resulting in the case of an easement for an electricity transmission line from the creation of a transmission line over the land and the creation of the easement, including severance and injurious affection. So they're heads of compensation that, yes, come into the forefront in assessing compensation, because we're looking at the use that's being put to. We spoke about land being acquired for sewerage farms and transmission, electricity type facilities, freeways. The acquisition of an easement for those similar type uses is no different. The impact is still there because there could be a huge reduction in the value of the retained portion because of the creation, the physical blight, or any other types of blights, noise, any other types of disturbances can be or should be taken into account in the assessment of compensation. And that comes into account in the after approach. What's the value of the retained portion once you have a transmission line smack bang across your property? So again, the exercise or the framework is reasonable and is easy. We understand what we need to do. It's coming up with a practical approach as to how you assess those figures. The damage which such an easement may inflict on a property is directly related to the highest and best use for which the land is suitable. We're talking generally when you create an easement that it has a nominal or a lower effect, but what if you had a property that could be developed with a number of units or townhouses, but the creation of an easement now dramatically impacts how many units you can fit on that particular development site. So again, the assessment of compensation or the impact of that easement might actually be quite considerable. The effect on overhead transmission line easements on urban sites is to greatly affect its utility and value, because normally a building cannot be constructed or over the easement area. And that's generally the approach that you would take for a compensation assessment, is that the owner of the property wouldn't be able to build over that easement. So what's the impact of not being able to build over that land? There's a difference, although the basic, the starting point of assessing compensation, as was stated in that first sentence, is the highest and best use. What is the highest and best use of that land, or what was the highest and best use of that land prior to the easement being created, and what is the highest and best use after? As I said, it could have a substantial impact on the value, well, not necessarily the value, but yes, the value ultimately, but on the highest and best use. Before, you could put a dozen units on a particular property. Now, with the creation of that easement, that now drops to maybe 5. So you can see it could have a huge impact. The value of land between a 5-unit site and a 12-unit site is enormous. So think along the lines of highest and best use as the starting point in assessing compensation. Where an easement is compulsorily acquired, the principles to be applied in assessing compensation is no different from those applying when the full fee simple is taken, when you're actually acquiring land, that means. For practical purposes, it becomes a matter of assessing the extent to which a claimant has been disadvantaged as a natural and reasonable consequence of the taking of the easement. Test is the attitude of the hypothetical prudent purchaser. So that's an interesting point there. So how would the purchaser take that into account if they were going to buy a property without that easement compared to a property with that easement in place? What would their attitude, how would their attitude change? And the extent to which, in the opinion of such person, the claimant has suffered reduction in the value of their property, severance and injurious affection. So any questions? I know we've lost a lot of that through the recording, but as I said, I'll attempt to upload last year's one. But any questions in particular about how we take into account easements? No, we're all generally pretty good. You sure? Okay, the next topic I wanted to cover tonight is compensation valuation assessment for businesses when a business premises is impacted. How do you take that into account? And I want to demonstrate the approach that you take by a particular court case that happened many, many years ago that I happened to be involved with, and that's known as Ramsdale Proprietary Limited and others versus the Roads Corporation, who were the old Vic Roads and now Department of Transport. So I'm not sure whether you know Fawkner or Camberfield well, Sydney Road, where the Metropolitan Ring Road, when the state government acquired land for the Metropolitan Ring Road, they acquired this particular business, and I was involved in the valuation dispute of the business, which ended up going to the Supreme Court. So let's go through some of the issues that came out of that particular court case. So it was heard by Justice Gobbo, who is probably viewed as the most eminent judge in Victoria in relation to land valuation disputes. So he headed up the Supreme Court. This particular court case was heard way back in 1992. And let's go through some of the highlights of it. So the premises on which a takeaway food business was conducted. So it was like a KFC, but not quite, but that type of property. And we've got was resumed for public purposes. We had the state government acquiring land, that's why it's resumed. The owner had secured a planning permit. Gets a little bit technical. The owner had secured a planning permit in 1983 to erect the food premises on the subject land, which was reserved under the planning scheme for a main road. So the reservation for the Metropolitan Ring Road was already created at that point in time. So the owner did obtain a planning permit in 83 to construct, sounds a bit strange. So the reservation existed for the Metropolitan Ring Road. They went to council, they applied for a permit to construct this building over that reservation, and they were actually granted the permit to build, which wouldn't happen today. But I'll explain why. So they went to council, applied for a permit, reservation was there, and the council approved the construction of this facility over where the Metropolitan Ring Road was eventually going to be constructed. The permit contained the condition that the use hereby permitted may be terminated by the responsible authority, delivering to the owner or occupier of the subject land at any time after the 30th of October 1993, notice in writing requiring the termination. Okay, so what does that mean in English? The council granted a permit, but with a condition, because they were told by Vic Roads or the Roads Corporation at that time, we're probably going to need it sometime around early to mid-90s, so 10 years after the permit was going to be granted. So the council said, okay, we'll give you a permit, but in the conditions, the permit we're going to say any time after the 30th of October 1993, the acquiring authority can terminate, well, the council will terminate the permit on the basis that the acquiring authority, being a Roads Corporation, will need this property for the Metropolitan Ring Road. So that's how they dealt with this particular issue. Of course, today, they would simply just refuse that application. But back then, they granted it with a condition. So the premises was leased in 1983 for a period of 10 years with an option for a further 3 years with power to terminate. So even there was a special condition in the lease that it could also be terminated in October 1993. So the lease had that termination clause. The lease contained an acknowledgement of notice of a road widening proposal. So the lease actually referred to the Metropolitan Ring Road project affecting the land, and an acknowledgement by the lessees that they had no claim for compensation in the event of resumption. So again, in the lease, it said that Vic Roads or the Roads Corporation could acquire this land for the Metropolitan Ring Road, but the tenant had no rights to compensation. So what are you thinking? Open and shut case? Anyone? You want to make a comment on which way this case goes? No? All right, let's keep going. The authority argued that the effect of the planning permit was that the claimant's interest in the land did not extend beyond the 30th of October 1993, or at any rate should be treated as having no value beyond that date. So Vic Roads was saying they're not entitled to any compensation because the lease said it and the permit said it. There was considerable dispute about the calculation of the compensation for the loss of the business. The main claim was for $400,000 for the value of the takeaway food business. This was eventually put forward as a claim for $388,800. The authority, the acquiring authority, offered the sum of $256,000 for this item. Its expert witness assessed the value of the business taken at $256,500. So in this particular case, which went to the Supreme Court, I was representing the tenants, so I came up with the 388,800 as a valuer. An accountant assessed the value for the acquiring authority at 256,500. So this was the rare case where you had a valuer also up against an accountant in the assessment of a business value. So interesting. So let's have a look at what the Justice Gobbo's decision was in relation to this particular court case, which went through the Supreme Court. The provision in the lease does not define the extent of the interest, but is concerned with excluding any claim for compensation against the lessor in the event of an acquisition before the end of the term. Secondly, the critical clause in the permit does not define the life of the permit, which runs with the land and is indefinite. It merely says that the use may be. So there were 2 points that the acquiring authority were arguing, and that is, first of all, the lease says that you can't claim compensation, and secondly, the permit also says that your right to compensation is affected, because the clause in the permit says that maybe after the 30th of October 1993, the acquiring authority might be taking that land for that particular purpose. And Justice Gobbo disagreed with both of those. So he's saying just because it says that doesn't mean that it's right, because the owner's rights are protected in the Land Acquisition and Compensation Act, irrespective of what the lease or the permit says, that everybody's rights are protected in there. So just reading that second point again. Secondly, the critical clause in the permit does not define the life of the permit, which runs with the land and is indefinite. It merely says that the use may be terminated by notice after the 30th of October 1993. It does not say that the permit must come to an end on that date. It is quite open that the permit may not be terminated at all, or that it may be terminated long after October 1993. So putting that clause in to the permit actually had no impact on this particular issue, because all it said was may. I'm accordingly of the view, this is Justice Gobbo, that in assessing compensation, the proper approach is to treat the interest as being one for a leasehold term of 10 years, and that the option for a further 5 years was also relevant to the matter of the extent of the interest. So Gobbo said, value on the basis that they had a 10-year lease with an additional 5 years. It was clear that the subject business was ideally located for a business of its type, and it had a record of proven takings against substantial opposition, fast food outlets such as Kentucky, McDonald's, Denny's, you might not have heard Denny's, or Hungry Jack's. The gross takings averaged 14,400 per week in the last year before the acquisition. The figures for sales averaged over the 3 years was 13,500 per week. So this independent type fast food outlet, which was called Rooster World, had nearby competitors, which included Kentucky, KFC, McDonald's, Denny's and Hungry Jack's. They were all pretty close. So it had operated for a fair length of time with that competition in place. And so it was a pretty established business. And Gobbo made a note of that in his decision. It was also substantially common ground. The evidence certainly established that fast food outlets such as the subject business were bought and sold by reference to gross weekly takings, usually warranted over a 3-year period and then multiplied by a multiplier that reflected the further potential or other special factors. So again, the job of the valuer is to try and replicate the market. And the market for these types of businesses, as Gobbo says, was based on gross weekly takings. So he said that's the proper way to value them. There were a number of sales of comparable type businesses that were identified, but he zoned in on these particular 5 and said these looked, in his opinion, were most comparable. So the first one was one in Bundoora, which sold the business. This is, remembering that we're valuing business here, not property, not real estate. But the business sold for $259,000, and that had 9,000 weekly takings. So that's a multiplier factor of 30. There was one in Wantirna South that sold for $295,000. And that was taking 10,500 a week, and that was multiplied, analysed at 28. Tullamarine, 395,000, weekly takings at 22,000. There were some issues with that, but the multiplier factor there was either 18 or 20.5. There was another one in Colac, 210,000, and that was averaging 11,000 gross weekly takings, multiplier effect of 19. And one in North Balwyn, 298,000, 10,000 per week, multiplier of 30. So they're our sales that we relied on. So Gobai goes on to say, on balance, I'm left more persuaded by the traditional approach. I accept this view that the lower takings sales help to set a minimum for the subject property at 300,000. There was more difficulty about the upper limit. This depended on both the takings and the multiplier. The proper approach, in my view, is to use the method indicated by the market. So that's an extremely important statement, which was based on 3 years takings, but to use a multiplier to reflect the special or added potential of the business reflected by all the material. Included in this material was a clear surge in takings in the last year. Also to be added here were the locational advantages of the subject premises and the improvement in takings in spite of the long history of intense competition. It is appropriate in these circumstances to adopt an assessment with suitable modifications, which leads to the conclusion that the value of the business at the relevant time was one based on takings of 13,500 per week, but with a multiplier of 24 resulting in a total figure of 324,000. In finishing up his decision, he said, I note in passing that neither expert had any reference to the sale of the business in November 86 for the sum of 300,000. Of course, this was too remote in time to use as a comparable sale, but it's interesting that on the takings figures for 86, 87, the multiplier shown by such a price was 24. It follows that the compensation payable for disturbance loss, being the divestment of the claimant's interest in the property, is 324,000, being the value of the interest being divested is not necessary to do so, but I find that the same compensation would be recoverable as special value. He also went on to say that claim for loss of profits into the future was dismissed, and any claim for solatium was also dismissed. So no emotional attachment. You've got a business premises here, so nothing in relation to solatium was also given. So quite an interesting case that, and clearly some principles came out of that in how to go about valuing these particular types of businesses, which in a nutshell means you replicate what the market does for that particular type of business. So compensation for business premises, let's have just a general view of what we take into account when we're doing that. Just to make it more interesting for you, I suppose I should throw in here that there generally is a question on the exam about evaluation of the assessment of compensation for business premises. So what do you take into account? When premises used for business purposes are compulsorily acquired, loss of business goodwill may be suffered by the occupier, whether they are the owner or the lessee. So you've got to remember that the valuation of the business is separate from the valuation of the real estate. In London County Council versus Tobin 1959, the courts ascertained the method in assessing business goodwill was to value the business in the old premises immediately before the transfer. They say this is in a situation where the business had to move, which in some instances would require to occur when part of a property is taken, then the capital value of the business in the new premises, and then comparing the two. So what he's arguing, what they're saying in that particular court case is a before and after approach. The valuation of a business as a going concern, including any attached goodwill, is required when the taking of premises results in the cessation or the finalisation of the business because of its complete dependence upon the site occupied and the unavailability of any other suitable premises. So what are we talking about there? So let's take into account a quarry, for instance. Now, a quarry, you can't just pick up and move down the road. A quarry is pretty well invested in that particular location. And so if part of a quarry was acquired for various projects, roads or anything else, it would be difficult to relocate. There's too many things that you need to organise to relocate. So a partial acquisition might pretty much finish off a quarry, and so that you'd have to value the whole business as if it was finished and not able to continue to exist. Where a business is conducted in premises held under lease, the valuation of the business goodwill must take into account the length of the unexpired term of the lease, any additional terms, and or the expectation of any renewal had the acquisition not occurred. So you are limited by the term of the lease. So if you had a 10-year lease with another 5 years, that gives you 15 years. That's a fair tenure to have on a property. But if you had an acquisition that occurred where there was only 2 years left in a lease, how are you going to value that? Who's going to buy a business that's only got 2 years to run? So there's a couple of things that you need to take into account when valuing under those sorts of circumstances. What's the likelihood that the business would have continued beyond that 2 years? And you can find that out by having a discussion to both the business operator and also the owner of the property. If they both confirm, yeah, we were going to be here forever, the owner would have granted another lease when we went and spoke to him about it. Or conversely, in some cases, not all, but in some cases where a relationship does exist between the owner and a tenant, there might not even be a formal lease in place. So does that mean they're not entitled, the business operator is not entitled to any compensation? No, not necessarily. If you can prove, or if they can prove, that the business would have continued to operate at those premises without a formal lease in place, then you can take that into account and value it accordingly. So business valuations are quite complex as well for us in assessing compensation, because you need to determine those sorts of things. Another point which is difficult to ascertain and to work out is if they didn't have a permit, but if they had non-conforming use rights, which means that use was there way before zones came into account, that a permit might not be necessary in those particular cases. So quite complex in the assessment of compensation for various types of businesses. Where the acquisition does not cause termination of the business, any goodwill attached to it is required to be valued so that any reduction in its value in its new location may be measured. And that's quite a difficult exercise, but possible to do. In Inland Revenue Commissioners versus Muller Limited 1901 case, goodwill was described as being the benefit and advantage of the good name, reputation, and connection of a business. It is the attractive force which brings in custom. It is the one thing which distinguishes an old established business from a new business at its first start. That's basically what goodwill in a nutshell is. Goodwill can be classified as either local or site goodwill or personal goodwill attached to the operator of the business. with the exception of Western Australia, none of the compensation provisions makes any direct reference to business as such. In ordinary circumstances, a claim for business losses which are due to the acquisition fall under the head of disturbance. So just remember that, that's quite important. Let's have a closer look on the various other methods of valuing businesses. There are no single globally accepted convention regarding a valuation methodology. However, there are several identifiable valuation techniques that are used in the industry. And they are conventional or trader's method, which is what we looked at in the Ramsdale case. Discounted cash flow analysis, obviously, because the business is earning income, or hopefully. So what's the value of that income stream? The capitalisation of future maintainable earnings is a method. Asset-backed valuation. So when you've got a business that owns quite substantial assets, then the value, obviously, in some of those cases is going to be in the assets. So if you value the assets, you've got the value of the business pretty well summed up. And the capitalisation of future maintainable dividends when you're looking at substantial type businesses, national and international companies, for instance. So let's have a closer look at what they actually mean. So the conventional or traders method, as I said, we had exposure to that in Ramsdale that we just spoke about, primarily used for small businesses and based on the number of units sold in that type of business. For example, number of loaves in a bakery, that's what you're buying, number of newspapers for a news agency. I know it's a bit more technical than just newspapers, especially now where it's all gone online. With the use of comparable sales, we can multiply the net maintainable profit by an appropriate factor. For example, let's say we're valuing a coffee shop. The coffee shop within a shopping centre might have the following annual figures over the past 3 years. Annual gross takings, let's say 300,000, all up. Annual expenses running, these are pretty clean figures, but let's just work with it, 200,000, so that you have net annual profit at 100,000. Comparable businesses show a multiplier impact of 2.5 times net profit. So therefore, this is pretty simplistic, but the value of the business would be net annual profit, 100,000 multiplied by 2.5, which gives us a value of about 250,000. Now that's the method that most buyers assess businesses when they go to buy. When you're talking about coffee shops, restaurants, bakeries, news agencies, all of those small types of businesses that's are purchased on a day-to-day basis within the marketplace. So this, again, as I say, valuers' methods of valuing properties and businesses is to replicate the market. What is the market showing? And the market shows that these types of businesses are valued in these ways. So the valuer needs to replicate that. So again, have a look at Ramsdale, make sure you understand the methodology in valuing this particular type of business. Discounted cash flow, a little bit more sophisticated, recognises that shareholders return, these are more valuable type businesses that we're talking about, recognises that shareholders' returns comprise dividends plus capital gains from share price increases. Also, discounted cash flow recognises economic cash flows, which is what you're buying, recognises the present value of money, allows for both the business risk, which is the nature of the industry in which the firm operates, and the financial risk, the extent to which debt funding is used to finance operations. So I know we're getting technical here, but you need to have an idea of how these various types of firms and businesses are actually valued. Allows for incremental changes to be made to capital as a result of forecast business growth. So that's your discounted cash flow methodology. The other method that I mentioned was capitalisation of future maintainable earnings. This approach relies on a judgment as to what is reasonable, a reasonable estimate for the future earnings of a business, and capitalising at a rate reflected by a reasonable price or earnings ratio, which you would obviously obtain from sales of similar type businesses, which I acknowledge is not always easy to access that type of information, but it is available out there. This valuation approach requires two parameters: the earnings the company can sustain into the future and the rate of return that accepts those earnings. So again, quite a sophisticated and more direct and precise value approach to those types of larger businesses. Asset-backed valuations is reasonably easy because what you're doing is valuing the assets rather than the business itself. Are generally used in the following circumstances: where a company is not expected to remain as a going concern, where assets are of prime importance to the company's operations and marketable in their own right. And think of a company that owns property. The company itself probably doesn't have a value in that respect, but if it owns property, those assets have a clear value. So maybe the company is only worth what those assets are worth and no more. Now, there are three types of asset-based valuation approaches: liquidation-based valuation. So in a fire sale instance, what would someone pay for the business? And again, that's going to be on what they think the assets are worth. Orderly realisation of assets. If you had time to sell it off the assets piece by piece, what would you get? And also net tangible assets, the valuation approach from that point of view. Again, I don't want you to be bogged down with technicalities of valuing businesses. I just want you to be exposed with the methodologies that are used in valuing these different types of businesses. And the final approach, capitalisation of future maintainable dividends. This method requires an assessment, and we're talking about obviously companies on the stock exchange. This method requires an assessment of likely future dividends based on maintainable earnings and the expected dividend payout rate and the determination of the capitalisation rate. So there's some of the methodologies that are used in valuing the various types of businesses. When business premises are compulsory acquired, the goodwill may be wholly or partially destroyed or not affected at all. Compensation will depend on the circumstances of the acquisition, the availability of alternative premises where the goodwill is largely reliant upon the location of the premises or is mainly personal in character, and the terms on which the acquired premises are held. And what we'll do, not next week, but the week after, we'll go through the exam papers, the past exam papers, and we'll go through some examples of questions that you might get in this coming exam paper too, which will most likely include a scenario where you need to demonstrate your knowledge of the process of assessing value of a business that's been caught up in a compulsory acquisition project. Compensation for loss of rents is also an important aspect. In Horden and others versus Municipal Council of Sydney, 1940, one effect of the resumption had been to cause delay to the plaintiffs in putting the land to a use which would give them a financial return. They therefore claimed the loss of rents derivable from the flats when completed. In the opinion of His Honour, however, the true measure of the damage due to the delay was the loss which would follow from the inability to put the land only to a productive use for the period in question, and not to the loss due to the inability to put the land. The effect of drought on value for compensation. During a lengthy period of drought, there is likely to be a decline in demand for rural lands in particular within adversely affected districts. In McCarthy versus Federal Commissioner of Taxation, 1944, The market value as a test, thought valuable and persuasive, is by no means final and conclusive, and it should not be used to depress the value of the property by exaggerating temporary disadvantages to which it is subject at the date of the valuation and failing to give weight to its more permanent advantages. So what does that mean, and why have I raised that particular issue with you? Well, I think it's important principle in relation to valuing property in the current circumstances of a global pandemic, because it could be argued by the acquiring authority that a particular property, especially one that's affected by COVID, I'm talking a hospitality-based premises, a hotel, for example. If a hotel is compulsorily acquired today, you could see an argument mounting that it's not going to have a great value because of what's been happening. And I'd be interested to be involved in a discussion of a business, a property in particular that's being acquired right now that might have potentially depressed value. But clearly in McAfee versus Federal Commissioner is that these sort of and I suppose you'd argue whether COVID is a temporary disadvantage, but generally these sorts of instances that occur are to be disregarded. Is a drought similar to a global pandemic? Yeah, it could be. And as I said, it'd be an interesting argument, but certainly no one can take advantage of circumstances when a compulsory acquisition, that's the acquiring authority and also the dispossessed property owner or anybody else that has an interest. So I think you need to be mindful of that particular principle in the assessment of compensation in the current circumstances, or in any circumstances that is temporarily reducing values. Also wanted to touch on the valuation of separate interests, which is known as the Rosenbaum principle. It has long been recognised that compulsory acquisition of land often involves the interests of more than one person or party. Now, I've been talking in the last, certainly in this class and also in last week's class, that you have, and the weeks before, that in a property you have numerous parties that have an interest. It's not just the property owner, but in a lot of cases it's also tenants, and that's what we're talking about in Rosenbaum. In the High Court of Australia, Justice Griffith stated, in every case of a lease, the ownership of land is divided between the lessor and the lessee. The value of the lessee's share in the total ownership is the value of the term. The residual represents the value of the reversion, which remains in the lessor. So what does Rosenbaum mean? So prior to Rosenbaum, well, during this case, the Rosenbaum principle was reiterated. And what that basically meant was that if you had a property and it was worth, generally speaking, say $3 million, it was a commercial property and was leased, and it was determined that it had an overall value of, say, $3 million, as I said, and it was determined that the lessee's interest, the business part of that value was say $500,000, then the courts generally under the Rosenbaum principle would then state, well, if the total value is $3 million and the tenant's or the lessee's interest is worth $500,000, then the value of the lessor's interest in that property is $2.5 million, because you can't have more than that $3 million come out with those two separate interests. So that was the Rosenbaum's principle. Of course, we think about that, and that was a pretty old court case, but we think about that today, and that's ridiculous, because the value of a property has got no meaning in relation to the sum that the lessor's interest is worth and the lessee's interest is worth. You don't add them, they're not connected in any way because they're totally separate interests. So Rosenbaum's principle was thrown out. This view was overturned in the proceedings, the Rosenbaum case threw out this particular principle, where it was established finally the value of each separate interest or estate in land which which is resumed, must be ascertained by separate valuations, so they're not connected as was previously thought. It follows that where the value of the various interests are separately ascertained, the sum of such values might well differ from the value of unencumbered fee simple. In other words, there's no connection between valuing those two separate interests. And as we've just seen, in going through the valuation process of determining what a business is worth, there's no connection in that process to real estate. So why would there be a connection between the lessor's interest and the lessee's interest? So just be mindful that Rosenbaum states that they're two separate exercises and not connected in any way. The Rosenbaum principle establishes it should be decided upon the true construction of the Public Works Act 1912, New South Wales. Each person or party having an estate or interest in the land, including a tenant, has a separate and independent claim to compensation for the value of the interest which is taken from her or him by the acquisition of the land. They have separate rights and separate interests. The right to claim compensation is subject to each claimant establishing that he or her has an entitlement to an interest in the land. Each interest must be separately valued. The court is not concerned with questions of title, but is concerned with determining the nature of the interests of those entitled to compensation. The court determining compensation would ordinarily have jurisdiction to determine the nature and the value of all interests. Matters to be taken into account that are relevant in the assessment of compensation. In some cases, the market value of the acquired interest may not fully compensate for which that has been taken. Acquisition statutes seek to fully compensate the owner in addition to market value by specifying the range of relevant matters to which regard must be had in the assessment of compensation. Now, again, the general rule is to put the person who's affected by the acquisition in the same financial position, which might, as we've discussed many times, includes adding more than just market value of the property, especially when a whole property is taken. It gets a little bit more complicated when part properties are required, but let's concentrate for this specific principle. If a whole property is taken, so there's no argument that the whole property is worth, say, $1 million, that's not adequate compensation. That's not putting the person into the same financial position. Whilst regard must be had to the specific matters, it does not follow that specific sum must be specifically allowed to each matter, provided that the matter is relevant or is properly taken into account. Now, again, I know that when you hear that, you're thinking, what the hell does that mean? But what that's saying is that everything that is relevant to that particular acquisition for that particular property must be taken into account. Now, you can't be more specific than that, because every single property that's acquired has different sets of relevant issues. So the Act clearly says, and the principles clearly say, that whatever is relevant in that particular case needs to be taken into account. In a before and after exercise, care must be taken to ensure that like is taken from like, and there is no double counting in the before and after. So make sure that you don't do that in your assignment too, that you don't double count for particular issues. Prudent inquiries, what does that mean? The prudent imaginary party to the hypothetical sale is assumed to be fully informed as to the relevant matters, but is not to be taken as possessing any special knowledge or facts or secret facts relevant to the valuation. So again, I know that that's very cryptic. What does it actually mean? So that, again, in Spencer, we're talking about informed, willing and informed purchasers and vendors. They know all the relevant matters to be taken into account in the assessment of compensation. The knowledge of the hypothetical parties to an assumed sale is limited to the knowledge of the purchaser at the date of resumption, and that comes out of Gosford Shire Council versus Green. The valuer is entitled to rely upon all the matters which would be likely to influence the price of land. The valuation should take into account all such matters, including hearsay. Such information is admissible in legal proceedings, not as evidence of fact, but to the data relied upon by the valuer. Subsequent events. Market value must be determined as at the date of acquisition, and in Spencer's case, it was said that all circumstances subsequently arising must be ignored. In some circumstances, events subsequent to the acquisition date can properly be taken into account in determination of market value. So, for example, sales after the relevant date of valuation. There's a different view of what you do with those sales, but I think they're relevant in showing a valuer or assisting the valuer to look at how the market went beyond the date of valuation. Now, that would be useful under certain circumstances. Events subsequent to the acquisition are always relevant in the determination of other matters such as disturbance, injurious affection in particular. Offers. The best evidence of market value is a recent concluded arm's length sale of comparable land on usual terms. An offer, of course, is not a sale, and for many years was rejected as inadmissible. It's not a transaction, it's not a sale, so how can it be used? But in some circumstances, it might provide useful information. It is now well established that offers can be taken into account and that a genuine offer is evidence of market and some evidence of the value of the land. And that comes out of a couple of court cases. So again, have a look at those when you have an opportunity. Sales to the acquiring authority. So we started talking about compensation valuations a few weeks ago with a notice of intention to acquire. So a notice of intention to acquire is telling the acquiring authority, telling or asking the owner of the property, can we start friendly negotiations to determine what is fair and reasonable compensation? So that's what a notice of intention is meant to achieve. So sales under those circumstances, can they be used as evidence of market value, do you think? Interesting. Sales to a public, so comparable sales must be examined to determine whether the price was affected because one or both parties were subject to compulsion. So you could argue the only reason the vendor or the owner of the property was talking to the acquiring authority is because if they didn't, they know the land was going to be taken from them anyway. So does that affect what they might eventually agree on? I'm talking about a sale of a property under the friendly negotiation process, not when they compulsorily acquire, because that's not evidence. But when the friendly negotiations are occurring and a sale price is agreed to, can that be used as a sale transaction? Sales to body with powers of compulsory acquisition and the agreements in settlement or anticipation of compensation claims are admissible but most useful when they are seen to be otherwise in line with comparable sales. So what that's saying is they can be used when they actually are agreeing with or in line with other sales of properties that are occurring. So they can be used, but they can't be out of line of what's occurring generally in the marketplace. Cost and value. The potential for future liability for costs for buildings or work such as demolition, filling, levelling or stabilisation is likely to have an effect on the value of the land. It should be noted that in the assessment of land value, that it is not the task of the valuer or the courts to determine precisely the cost of works which might affect that value. The test is what effect that would the potential for such costs and any uncertainty as to the level of such costs have on the agreed price in a hypothetical sale. That comes straight out of Bergman versus Holroyd Municipal Council, 1988. Zoning. In general, all relevant factors which have an effect upon value of the land at acquisition date, either upwards or downwards, must be taken into account. However, if a nexus can be established between a step taken or not taken, which affects value, and the intention to acquire the land, then the effects of such steps by way of increasing or decreasing is to be ignored in the assessment of the value of land. What does that mean? So we're talking about land that is in an area, and similar to where the subject land is in assignment 2, that it's in an area that's being rezoned. It's not rezoned at the moment, but is being rezoned. So, for example, if an acquisition occurred today of land of a property that was zoned farming, but land not too far off has just been recently rezoned from farming to residential development, how do you take that into account in the assessment of compensation today when it's still farming zone? The answer to that question, anybody? Who wants to have a guess? How would you value property of land that might have potential to be rezoned but hasn't quite happened? No one wants to have a guess?
Is it Point Gord?
It is a bit of Point Gord, because Point Gord is the land has already been rezoned, so that's already occurred. So it's prior to that happening. So the rezoning hasn't occurred yet, but is going to happen. So how as a valuer would you take that potential into account? So the answer is comparable sales. When I say comparable sales, sales of land that are zoned farmland, but that has a potential to be rezoned soon to residential development. So the sales should show you that there is a difference in farmland value that's going to remain farmland and farm properties that could have this potential. So I suppose the challenge is, if you don't have any of those sales, what are you going to do? Well, you're going to value it higher than farmland because it does have some potential. How do you take that potential into account in actual valuation process? Well, you might, in that particular case, get a town planner consultant involved and get them to give an opinion as to the likelihood of rezoning occurring. But certainly you can take into account that potential rezoning possibility, and that's what that particular reference is for. So that finishes up what I wanted to cover in our last class. So you must be all experts now in rating and taxing valuations and also compensation valuations, correct? Any confirmation of that? Now, we've still got plenty of time, so any particular questions or issues or problems that you are having on assignment 2 before you finish up tonight?
Hey, Gino.
Yes.
For assignment 2, for the sales evidence, are we able to use evidence outside of those 2 documents that have been provided to us?
Absolutely, but there were 3 documents. You might have lost
really?
that. Yeah. So we had some
Is
issues.
it all onto the assignment 2, like the assignment 2 tab?
Who can help me? I can't remember now where I stuck it. Say again?
The one.
The documents on modules instead of the assignment.
Did you get
I
that?
missed that. No.
Who can help Bianca? Where are the 3 documents?
Just go on LMS and there's an additional one in the modules, and I think it says Sales 3 report. I can double check.
Yeah, okay.
So there should be 3.
Yeah, it's all
Thanks, Bella.
Okay. All right. Thank you very much.
But to answer your question, yes, absolutely, you can go anywhere you like to get some additional sales. No worries.
Okay, cool. Yeah, thank you. And also in the report, should we be assuming that we've done a site inspection?
Yeah.
Okay, cool.
Yep.
Thank you.
Then you've walked on the land, you know, back to front.
Yeah, cool.
Any other questions?
Gino, in the sales evidence you give us, I couldn't find some information about like public acquisition overlay in related to those sales. So should we just search in each sales to see if that is relevant to that price?
Yep.
Oh.
Yep. But you've got my permission to assume that if you can't find that information, assume that it doesn't exist, like there's no public acquisition overlay. I'm happy for you to proceed down that path.
You mean for the subject property or for the sales evidence?
For the sales, because the subject property is clearly got an acquisition overlay over it, because that's the acquisition that's occurring. But for the sales, if you can't find that information, don't get bogged down in that particular issue. Just assume that there's no acquisition overlays on those properties that you're actually using as direct evidence.
Sure, got it. Thank you.
Just in terms of the current use of the site, is that, I know there's a dwelling on it and then there's heaps of vacant land. Is that just straight unimproved land, or is that used for agricultural purposes?
Nah, again, assume it's not being used.
Okay,
So
cool.
that's not going to make a difference for your assessment as development land, because who cares if it is being used. Might have an impact on your rural part of the property, but yeah, you can assume there's no specific use in place at the moment.
Okay. I have another question actually. When we're analysing comparable sales evidence, when we're analysing land that's zoned as green wedge zone, if there's a section of the same lot that is rural conservation zoned, would that be considered as encumbered land?
Can you just repeat that? I don't think I followed you there.
So when we're assessing our land sales that are zoned as green wedge zoned, if there's a portion of the same site that's rural conservation zoned, would that be considered as encumbered land?
So rural conservation is not necessarily encumbered. It's just land that's got a different highest and best use, different use.
Yeah.
Is that what you mean by encumbered?
Yeah, I just mean in terms of like developing on it. Can you develop?
It's probably using the word encumbered is not quite right. It just has a different use, allowed use.
Yeah.
So urban growth zone land allows you to fully develop. The other land still allows you to use it. It's not as if you can't use it, but you've got to use it in a rural manner. So whatever the zoning allows you to do.
Okay.
Does that answer your question?
Yeah. Thanks.
All right. So you're all okay to finalise assignment 2, is that right? All right, let me throw down a challenge to you. Who's done enough work that can do a mock cross-examination right now for bonus marks? Just so everybody gets a feel, and I'm going to be cross-examining you, obviously, but just to get a feel, so the students or the rest of the students get a feel for what to expect next week. Bonus marks.
I can go if no one else wants to.
Really?
Yeah.
Good girl. All right. You got your information in front of you?
Hang on, let me just pull it up.
Are we getting cross-examined next week or the following week?
Next week.
Okay.
So your assignments, when's your assignment due?
This Saturday.
Saturday?
Yeah, Saturday, 5 p.m.
No.
So, all right, don't have a heart attack. You can have an extra few days, but you've got to have it finished by next class because you're going to be quizzed on it. So it doesn't help that you're not going to have it finished. So, yes, you have to, the cross-examination or the mock trial happens next week, and then we do revision, and then we're done. So that's all good news. All right, you ready, Bella? You got all your information?
Yeah, nobody judge though. Like, see how we go.
All right. I'm going to put the timer on because I don't want this to go for ages. I'll let you know what a reasonable amount of time is. All right, that'll be good. Okay, so can you tell the court your experience that you've had in the valuation of these particular types of properties?
So I've been a certified valuer, specifically in the compulsory acquisition area for over 20 years.
Okay.
And I've had many opportunities in court doing these sorts of cases.
Okay. So you're an old hand at doing this sort of stuff.
Yeah.
So can you tell us the last time you were involved in a similar valuation of this particular type of property?
I was involved in a very similar case last year that involved, very similar to this case, the acquisition of partial acquisition of land.
In this area?
Within close proximity, so 5 kilometre radius in the suburb of Doreen.
And how many valuations would you have done in the last couple of years in this region?
Oh, multiple hundreds for sure.
All right, so you're a true expert.
Yep, definitely.
Okay. All right, so can you explain to me, first of all, how you valued this property in a before approach, please?
Okay, well, first things first, I very much based my valuation on the Calder case, where they valued the subject holder.
Yeah, I didn't ask you about the Calder case. All I simply wanted you to explain to the court was how you arrived at the valuation of the subject property in the before method.
Okay, so I
don't see how Calder case has got anything to do with it. I'm just asking you to value the property as if no acquisition had occurred.
Okay, so in terms of valuing the property as is, I took an approach of doing a sum of parts because there are 2 parcels on the land that are under different zones. So I therefore had to take a price.
Last time I looked, it was 1 parcel of land. I'm not sure which your second parcel is.
It is 1 parcel of land. However, in valuing the sale, you need to value 2 hypothetical parcels as they're zoned under different overlays.
What are the 2 zonings?
There's Green Wedge Zone, which is for roughly 60 hectares, and then there's the Urban Growth Zone, which is roughly 20 hectares.
So why can't you just use one figure, one value, and apply it to the whole property? Isn't that how you normally value properties?
Essentially, yes. However, in this case, because there are different highest and best use attributed to the different zonings, we therefore have to account and take different prices per hectare.
So rather than just use one rate for one portion of the property, another rate for another, why don't you just use sort of a hybrid, something in between, and just apply it right across? Isn't that what valuations is all about?
Not necessarily, because it doesn't essentially, I guess, what's the word? It doesn't reflect, again, the highest and best use.
But the property down the road that's got 2 zonings on it, that sells for $3 million, right? It doesn't sell for $1.5 million or $2 million and $1 million. It sells for one figure.
Correct.
So why not just divide that by the land area and then use that to value a similar type property? What's wrong with that approach?
Because that's inaccurate.
It's inaccurate, but if the property sells for a figure, that's one figure that it's selling for. You're saying to me and to the court that you're actually coming up with 2 figures. That to me doesn't sound, that sounds inaccurate to me.
You're adding the 2 figures of those 2 different zoned parcels and then coming to one.
All right, so let's move to the after approach now. So as far as I can see, you've got the before wrong. So let's move on to the after. Maybe you got that right. How would you go with the after approach to the valuation of the property?
So the after approach.
And don't tell me you're going to value that in two parts, because I'll lose it if you do that.
I had to take into account the parcels being acquired by Vic Roads. Now, one area of the land was PA 06 1, and that.
Yeah, you're losing me. Let's go to comparable sales. Maybe you'll have a bit of better luck on the comparable sales. Which is your most effective, the most comparable sale that you have been able to determine or analyse?
What type of land would you like the comparable sale for?
The property. I'm asking you to give me a figure on the value of the property in the after, because I couldn't understand what you're doing in the before. So let's concentrate on the after. So which is the most comparable sale that you've used in valuing the land in the after method?
But I can't take just one property. You have to take properties that are.
There's more than one?
Correct.
How many? How many are most comparable?
There'd be 4 for each zoned parcels of land.
8.
Yes.
You need 8 sales to determine the value of the subject property. I thought you've been doing this sort of stuff for years. All right, let's move on to some basic information. So what are the allowable uses under the 2 zones that are on the subject property?
Okay, so in terms of urban growth zone, you're looking at residential subdivision use, potential for commercial use, whereas green wedge zone is primarily for the protection of the agricultural.
What's the date of the valuation that you're doing, just as a matter of interest?
It is the 8th of October 2021.
What's the closest sale that's occurred to that date? Can you tell me?
Yes. It is 10th of December 2020.
That's almost a year before the relevant date of valuation. That's your best sale. That's your closest sale in date.
Well, we have been under a very specific economic climate with COVID, so I believe that.
So describe me that specific economic climate. Is the market for this type of property improving or declining, in your opinion, with your 30 years experience?
There's a steady improvement as we're coming out.
Steady. What's the definition of steady? All right, let's move on. What's the closest sale in relation to proximity?
That
location.
Would be 270
distance.
Grants Road.
And how far away is that from the subject property, distance-wise?
Distance-wise, it would be within 500 metres.
Oh, okay, well, that's a good sale. What did that show per hectare overall?
So per hectare, so this was attributed to the Urban Growth Zone 6. So that sold price per hectare at 2.3 mil. I mean...
And what's that? And what's that per hectare?
Oh, per hectare is 58,000, sorry.
So did you use 58,000 per hectare on the subject property in either before or after?
I used 75,000, which was attributed to...
That seems way over. Are you sure you've done this sort of valuation before, this type of property?
The property that I had much relied upon has almost the exact...
What's the worst sale that you used in your analysis?
I didn't use any worse sales. They're all good sales.
Well, what's your lowest analysed value that you came up with the 8 sales that you used?
Well, in terms of urban growth, the lowest price per hectare was the 270 Grants Road.
And what did that analyse? That was 500,000, did you say? 500. What was it?
It was $60,000 per hectare.
But you chose to use more than that.
Correct, because...
Are you related to the owners of the land? Are you just doing a special deal here? Because why do you use more than what that sale analysed to?
Because there was another sale at 345 Tots Road.
We didn't mention that sale. You reckon this one's the best. So why are you referring to another sale now?
Because I said previously that I'd relied upon multiple sales.
So how many sales did you look at
Overall,
overall?
I'd say 16 to 20 overall.
All right, so that it's actually, that gives you a little bit of a taste of what it's like. You did well. I mean, it is difficult to clear your mind and say what is important in your evaluation assessment, but you can see how you can get flustered and the job of the it's coming now. So that was 10 minutes. That was pretty good.
How long will we be going for on the day?
So I think there's how many people are there? Let me just stop that so I can. So there's probably about 20. It's probably going to be about 20 of you. So we'll probably 5 minutes, which doesn't sound like a lot, but when you're under the hammer, how did that feel, Bella?
Yeah, it was fine. I just didn't expect you to come at me like that. So now I know to be prepared.
So yeah, so I've taken it a little bit easy on you because you're the guinea pig, and I thank you for putting your hand up. But next week, I won't be holding back because you all have to be 100% confident in what you've done. And because Bella wasn't expecting me to go at her, you get to see that it affected her. But the purpose of this exercise is for you to be clear, concise, and able to answer the questions reasonably quickly, whatever I throw at you. That means you're meant to know really, really well how you've arrived at this particular valuation and be able to answer it accurately and confidently and quickly, which is not always easy to do when you've got someone yelling at you and trying to throw you out a bit. But that's the whole exercise. That's what cross-examination is all about, being able to answer questions because at the end of the day, what this exercise is meant to show you is that when you're queried on how you've arrived at this valuation, can you articulate that what you've done is correct? Because one person is trying to say to the courts what you've done is not correct, and to not to believe or not take into account what figure you've come up with. Because the reason we're at court is because there's a dispute as to what's fair and reasonable compensation. And the aim of the cross-examination is to make you or make the court convince the court that you don't know what you're doing, that you've made an error. Now, I wouldn't go that far for Bella, but there was a little bit of hesitation in the. I mean, some of the questions you answered really well, but I think you probably, and the fact that it was your first one, you did do really well. But where you were not giving concise and quick answers because you weren't aware of what was going to happen. Sometimes that makes you then get into a bit of you're not clear in your own mind what you want to say even though you're clear in your valuation approach, but you couldn't articulate it quickly. So it isn't easy, and these people who are doing asking these questions on how you've done it, and I've been in that situation many times, and the good ones really just know how to get under this, your skin. And the answer really is to try and stay calm and to just talk with the confidence of what you've done is correct. But when you've got someone yelling at you, and as I said, I took it a little bit easy, but next week I'll be doing it a bit more aggressively, is to just be sure as to how you've assessed compensation is what the legislation allows you to do. So, Bella, you get some good extra points. Did you want to have another go next week? Don't have to. You've already done it. But
No,
I wouldn't
definitely do it again. That was terrible.
I wouldn't say that.
It was.
But it's not fair. It's not fair that I put you in that situation. But it gives everybody an idea of what to expect. So just be prepared. Now, I don't want to scare anybody because I know that some people just don't like having someone aggressively asking questions to you. But what I'm trying to determine is, are you absolutely 100% sure that what you've done is correct? And now, the problem is if you're not, it comes up pretty quickly. It's difficult to bluff that you've done it. So that's just another way to make sure that what you've done, and by the time you finish this exercise, you're pretty sure that you've done the right thing in the assessment of compensation under assignment 2. So we'll be a bit more formal next week in this, and we'll go through the exercise. Question is, how are we going to choose? We might start with see who's happy to go first. I might give a bit of an incentive to those. Otherwise, I'll just pick students. Doesn't matter who goes first. Everyone has to have a chance. So it doesn't really matter that. But I can understand some students might be nervous about that sort of process. This is not to trick anybody up. It's because everyone, as I said before, everyone's going to be involved in a court case. That's just absolutely how it's going to happen. And this is just a way to, and it's not anyone's fault. That's just how we are in the circumstances right now. So be prepared for it. It's not to trip you up. It's not to make you feel silly. It's just a matter of, you've done the assignment 2. That's fine. Now I'm going to ask you some questions so you can answer how you've done it, and you're feeling confident that what you've done is fair and reasonable. So we'll go through that exercise next week. I don't think it'll take you the whole time. So what we might do then is start our looking at some of the exam questions and revision. And I know it sounds as though it's been a long time since we started on statutory valuations for rating and taxing purposes, but we'll go back and start that exercise too. So we might make a start on that. I've finished the exam, so I know what it's going. I don't know if you guys all got your dates yet for your exam.
17.
Yep. So you know that's happening. So you need to be sure that you're satisfied with all of the items that we've covered over the last since the first class. So we'll go back to rating valuations and make sure you're familiar with that, and we'll go through last year's exam paper. Is probably going to be the most relevant. because it's you're all doing it in your own space, so it's different from what we've done in previous years, which is a closed book exam. Now you've got access, so we have to change a few things. So we'll go through next week, start next week and the week after, but make sure, I know you concentrate on one thing at a time, and so you'll be concentrating on assignment 2, but I also want you to start looking at what other areas you want me to change, check, and be sure that you know exactly what to do in an exam situation as well, because I want to make sure you all get through this particular subject. So you can either ask me now, or we can talk about it next week. But is there anything in particular that you'd like to, what you want me to cover in the next couple of weeks, or you prefer to do that some other stage after you get past next week's class? Anyway, you guys think about it. Let me know if there's something in particular you want me to cover. I'm happy to do that. But in the first instance, finish off assignment 2. And if you need some additional changes or completions, let me know. I'm not fussed, so long as you're finished by this time next week. Let me know, and we'll send that through, and then we'll follow off with I'll try, and you've got to be prepared for me to go in hard. So, but I don't want you to worry about it. But that's the whole idea, is to ask you how you've done the evaluation approach, and some might be a difficult approach to do that, but just be prepared of some questions, some hard questions that I might be asking you to undertake next week. So if you're happy for me to ask some questions early on next week, send me an email saying, yeah, I'm happy to go through in the first instance, and that might get you some marks. Otherwise, we'll just go through the system, and we'll do student after student, and I'll give you some questions as to how you've done your evaluation approach, and we'll go from there. Any specific questions on what we're going to be doing next week? We're all okay? As I said, if you're going to struggle, you got a question?
Yeah.
Do you know?
Oh,
Yeah, you go
go ahead.
first.
No, you go.
Somebody?
So with the sales evidence that we use in the report, how many comparables per zone of land would you like? Or would it be fine to have 5 to 6?
Whatever you, I'm happy. I'm not. I don't want to necessarily give you an idea of what you need. I want you to analyse the sales and make up your own decisions as to how many you think is fair and reasonable. Bella's picked 8. Yeah, that's fine with me. I'm okay with that. There's no issues there. You might take less than that. You might take more. It's what you think is the most dependable to use in your evaluation approach.
All right, cool. Thank you.
Gino, do you think that it's reasonable to evaluate in the before method? In the before approach, we evaluate it's divided by the zoning. So one parcel at the urban growth zone, one value for that part, and the other part for the green wage, and adding both of them as a sum of the value. Because like your cross section for with Bella, you said that might be kind of unreasonable. So kind of confused.
I was just
just on a roll.
Yeah, I was just trying to make her throw her confused and thinking that she's done incorrectly in what she's processed. So did that work?
A little bit, because I was like, hang on, you literally told me to do this last week.
And the more you're thinking, oh shit, Jesus, am I doing something wrong? Then that suggests to me that you're not entirely correct. So you need to be 100% correct of what you've done, because if you haven't, then you haven't really thought accurately enough what I've been telling you for the last few weeks as to how to assess compensation. So no, she did fine. I was just trying to make her think that what she did was incorrect.
Okay,
but
I got it.
That was a funny approach, but that's not fair. I just wanted all you to know that you've got to be 100% correct what you've done, no matter what I say.
Sure.
No worries.
Also, Gino, with the comparable sales, so you know how we take multiple? I think in previous classes that I've done, they've always said to only ever use the most comparable. But so if we're taking multiple, do we take the average, or do we use the most comparable for each different zone?
So as Bella says, it's a real difficult one, because you've got part of it's zoned development and part of it's zoned rural. So what do? But the only way to do that, as we've spoken about, is the Calder decision says that you really have to decide on how much you charge on the various zonings. So in this particular case, you've got two. So you've really got a value by per hectare on what the residential development land's worth, and also separate unit what's the rural value worth. So it's almost as she said, it's valuing two different portions of land. So the problem is that we probably don't have enough of development land for residential development in that list, but you've got to analyse what you can get and come up with what you think is fair and reasonable for the different portions, if that helps.
Yep, awesome. Other thing is there any rights that we should know as an expert witness that we're allowed to, how whenever you see people come before the Senate or something, they're usually allowed to finish answering their questions and not be interrupted? Are there any things like that for expert witnesses?
Well, our acknowledgement said in that account that started a few weeks ago by Stuart Morris, he gave us an idea of what to say, and and it's a good idea to listen to his assignment again. That's going to help you. But in most cases, you can the lawyer who is working with you, he or she will sound so that you can say what you like in relation to how you valued the zone. So that's fine. But in particular, in this case, I'm going to be the solicitor that's working against you. So my purpose is to ensure that I don't give you the rights to say the proper thing. So my job is to show each of the students that I don't agree with how you've done your valuation approach. So this particular case that we'll be doing is the opposite to what you're going to be normally saying with your solicitor. So that's how it actually happens. Your solicitor will start the court case by you explaining how you valued, and they'll be saying that case to support your approach. But we're not going to be focusing on that. We're going to be focused on, my role is to represent the acquiring authority. So you're doing the valuation for the property owner, right? But I am asking your case how you've arrived at the valuation on behalf of the acquiring authority. And so this particular case is about how you answer those questions that I will be asking for you to approve to show how you've arrived at that valuation approach, how you've arrived at assessing what is fair and reasonable compensation. Under normal circumstances, as I say, you'll be able to say what you want to say through your solicitor. But in this case, that's not going to happen. I'm going to be going against you for a few minutes to show the VCAT that what you've assessed as valuation, as adequate compensation, is incorrect.
Cool. Okay. Thanks.
No worries.
Also, unless anyone else wants to go first next week, I don't mind going.
Cool. All right. But can you send me a notice that on my emails just so I can get you as the first start?
Yep, sure thing.
Very good. Excellent. So be ready. Have your details accessible so that as I ask a question, you'll be able to answer that based on your workings. Good. And that goes for everybody. Have that information at your handle, and we'll see how we go. I'm looking forward to it. Be good.
Gino, would you be able to upload this recording as soon as you can so I can just watch back and take note of the questions you're asking, please?
Yeah. That's the recording tonight that we did.
Yeah.
All right. I'll also last year recording as well, so you've got both of those.
Oh, can you show us the mock of last year? Maybe.
That's a good point. I'm not sure. I can't remember whether we did it. Let me see if I can look for it.
All right, thanks.
Yeah, no worries. All right.
Oh, and one last thing. I'm not sure if we've received our marks for assignment 1, or maybe I haven't looked correctly.
I haven't finished them all yet. I want to do it all together, but I'll do that and finished in the next few days. So you've all got that idea.
Yeah, no rush.
No rush.
Thanks.
Any other questions? All good? All right. You're all happy about next week? Excellent. Can't wait for it. Have a good week. If you got any questions, yell out. Either text me or email me, and we can work on how your particular assignment's going. Otherwise, let's go with questions, how you've applied your assessment for compensation. Have a good one. Catch you all. Bye.
Awesome. Thanks, Gino.
Have a good week.
See you next week. See you guys.
Bye.
Thank you, Gino.
No worries.
Thank you.
Have a good week.